Good morning. We'll go on the record on KCR 22-21-1624, State versus Lori Vallow. This is the second day of jury voir dire. The court will note that the defense is present, Mr. Archibald and Mr. Thomas, along with their client. The defendant, the state is here as well, Mr. Wood, Ms. Blake, and Ms. Smith representing the prosecution. Is the state ready to proceed?
Yes, Your Honor.
All right, is the defense ready to proceed?
Yes, Your Honor.
Okay, at this time we will instruct the bailiffs, if they would, to bring in our next group of jurors for individual and group voir dire. As they're being brought in, I'll just note the juror numbers in the group that I see, so we're all on the same page, should be jurors number 401 through 891. Okay. These are some of the jurors this morning getting in, so we're just waiting for them to be lined up, so we'll just wait until they're here.
All rise, please. Pens all set, Your Honor.
Thank you. Please be seated. Okay. All right, ladies and gentlemen of the jury, thank you for returning to court this morning. You have been recalled as prospective jurors in the case now before us. The court will note on the record as we commence, we are on case CR 22-21-1624, State versus Lori Vallow. Parties are present as well as counsel who will be introduced additionally in a moment. I'll introduce my court staff here again for you. My name's Judge Stephen W. Boyce, and I'm the District Judge for Fremont County, Idaho, and I'm in charge of the courtroom and this trial. The court clerk assisting me is Shannon Holstein, who will be keeping minutes of these proceedings, marking any exhibits, and will administer oaths to you as jurors. The bailiffs are assisting us this morning as well, Deputies Ravello, Holmes, and Beish, and are assisting in maintaining courtroom order and working with the jury. The court reporter is Patty Bath, who is taking a stenographic record of what's being said in these proceedings. And my staff attorney is Courtney Stallings, who's seated over by the window at the table, and she'll be assisting me on legal issues that arise in this case from time to time. Each of you is qualified to serve as a juror of this court, and each of you filled out a questionnaire that was provided to you last week, and that's now been reviewed by the court and counsel, and you've been determined to be recalled for further questioning. So the first thing we'll do for the trial is to select 18 jurors, which will be 12 jurors and 6 alternates from among you. At this time, I will request that the clerk conduct a roll call of the jurors. So when your number is called, I'll also indicate to only refer to jurors by their numbers. I'll have each of you just raise your red card number and say here once that's called. So Madam Clerk, would you please take a roll call at this time?
Juror 401, Juror 536, Juror 549, Juror 615, Juror 631,
Okay. All right. Let's go ahead and let me hand the seating map to the bailiff and make sure we're seated in order. Sure. We'll get you reseated so you match the diagram that court and counsel has. So a few of you will need to move around.
It makes sense in a second. 416, 15, and down one. Right there. And sir, you're going to go to that seat on the end, still around the front. Now they're all seated, Your Honor.
Okay. All right, thank you for that, Mr. Bailiff. That'll ensure that we know who we're talking to throughout the proceedings with the chart that we've all been provided. At this time, then, why don't we just start over with the reseating, and I'll have Madam Clerk please take a roll call of the jurors.
Juror 401, Juror 536, Juror 549, Juror 615, Juror 631. Juror 646.
Here.
Juror 667.
Here.
Juror 676.
Here.
Juror 682. Juror 818.
Did we have a 696?
Sorry. Juror
Okay.
696. Juror 818. Juror 849. Juror 863. Juror 869. Juror 891.
Okay, thank you. As we get started, then the court will indicate that this matter is being simulcast to remote viewing locations here in both Ada County and a location in Madison County, Idaho. Those viewing locations are subject to a court conduct order, and in that order, the use of any electronic device to record or photograph or transmit any sounds or images from those viewing locations is strictly prohibited. The court has given the authority of the bailiffs monitoring those locations to confiscate any devices if anyone runs afoul of the terms of that conduct order, which is posted at those locations. I'll next discuss the introduction of the case and the parties at this time. So, ladies and gentlemen of the jury group we have here today, to assist you in understanding and participating in the jury selection process, I'll reintroduce you to the parties and their lawyers, and then I'll briefly summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel and then retake your seats. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is represented at this trial by Lindsay Blake, the prosecuting attorney for Fremont County, by Rob Wood, prosecuting attorney for Madison County, and by Rachel Smith, specially appointed prosecutor for this case. The defense is represented by Mr. Archibald and Mr. Thomas, and the defendant, Lori Vallow Daybell, is here present as well. Thank you, counsel. This case is a criminal matter, which means that the defendant is charged by the state of Idaho with a violation of the law. When you were here last week to complete your questionnaires, I read a summary of the charges as contained in the indictment. I'll give a more shortened version of that summary at this time in regards to the charges. So the state of Idaho alleges that Lori Vallow Daybell committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, count 7, grand theft. The defendant has pled not guilty to all of the charges. Please remember, this is simply a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. At this time, I'll discuss the juror's duty. The duty of the jury is to determine the facts and then apply the law as set forth in the instructions I'll later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you are instructed that you are not to discuss the case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. On that point as well, the court will note on the record, I received the signed juror affirmation notices this morning indicating that all jurors have complied with that admonishment given to them last week when they left with the after completing questionnaires. At this time then, I will ask the clerk to administer the oath to the jury panel. So ladies and gentlemen of the jury, if you would please stand and raise your right hand, I'll have you placed under oath.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by the court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
All right, thank you. You can be seated. At this time then, the clerk has impaneled 15 prospective jurors for questioning from the small group today. Will the state stipulate that the jurors are properly seated and called and impaneled this morning?
Yes, Your Honor.
Thank you. Will the defense stipulate to that as well?
Yes, Your Honor.
All right, thank you, counsel. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by other factors. Please understand that this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, you can either raise your hand or when you're called upon to speak, please just raise that red card number. That's how it's most easy for us to identify who's talking and keep that clear on the record. I'll note that with the simulcast into the other viewing locations, the cameras are not showing you as jurors, so there is no video of you. You're only referred to by your juror numbers so that you can be so that kept confidential in the matter, and your personal identities are not revealed through that simulcast. Because the proceedings are being stenographically recorded by a court reporter, when you're communicating with the attorneys or with me, it's necessary for you to speak clearly, and when you answer the questions, please use audible responses such as yes or no instead of shaking your head or nodding or saying things like uh-huh or because then we don't know what was said when we go back and read the record. Also, if you would avoid talking at the same time as anyone asking you a question, that will help our court reporter keep a clear record as well. If you do have anything that you feel should be discussed privately because it would be embarrassing or too revealing about you, something personal, we can do that without, we have capability of talking to you individually, one-on-one, and also not broadcasting that portion of the proceedings if there's a topic that requires that. So please keep that in mind as you're being questioned today. Also, there will be questioning for a lot of you as it relates to your pretrial knowledge of this case. Many of you have previously been exposed to some information about this case through pretrial publicity, and we'll be talking to you each individually about those issues. I would ask that during the course of the questioning, when you're all together, please avoid discussing any particular facts or knowledge about this case, so those jurors who have not heard anything about the case don't hear that information from you for the first time here today. I'll also instruct the attorneys if they'd please avoid repeating any questions that have already been asked by the court in its voir dire, but the attorneys do have the right to direct follow-up questions to jurors regarding the jurors' responses to any questions that would make that appropriate. The jury should be aware that during and following the voir dire examination, one or you may be challenged. Each side has challenges Some are called for cause, by which I mean that a juror can be asked to be excused for some specific reason. In addition, each side has a certain number of what are called peremptory challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving any reason for that dismissal. If you're excused by either side, please don't feel offended or feel that your honesty or integrity has been questioned, because it has not. The court will now commence with its voir dire examination of the jury panel, after which the attorneys for both parties will be given an opportunity to make their own inquiries. All right, I'll start off with the questionnaires that you completed next week. Each of you has completed, and we've received the responses that are contained in your jury questionnaires. I'll ask you as a group then, are the answers given by each of you on the juror information form still true and accurate? Yes. Okay, all the jurors indicated yes. Let's next talk about the time commitment required if you were to serve on this case. If you are required to serve as a juror in this particular case, it would be for a period of approximately 8 weeks, and the question is, would that create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case? So if there's anyone that has a response to that question, if you'd please hold up your red card. All right, on the front row, jurors 667, 615, and 549 have raised their cards. On the back row, 969, 682, and 676 have also raised their cards. So we will take those questions up for each of you individually, and if you'll give me a moment, I'll start reviewing your responses in your questionnaire. So starting with juror number 549. And 696. Okay, we also have juror 696. All right, juror 549, the court reviewed the detail of your questionnaire and didn't see any mention that it would be a difficult obligation for the time frame. Would you explain what you believe the hardship would be if you were required to serve?
Just being self-employed, being able to make ends meet financially for my family. We're a family of 5.
All right, and you're currently employed, correct?
Yes.
And in your family, do you have a spouse or significant other that also works as well?
No.
All right, so are you the sole primary provider for finances for the household?
I am, yeah.
Have you discussed with your employer the possibility that you may be required to serve in this case?
I have, yeah.
And do you know what their policy is regarding any compensation you may be able to receive while you're serving on a jury?
I'm part-time with my employer. I'm full-time self-employed. So I teach music lessons, and so I talk to my clients and let them know that this came up, but I don't receive compensation for hours not worked. But with my part-time employer, they do have jury duty option, but it's unpaid time off, any number of hours.
Unpaid time off?
Yeah.
Okay. Let me ask the state if the state has any follow-up questions for juror 549.
We do not, Your Honor, and we would not object based on the representations made by him today of him being excused.
All right. What's the response from the defense as to juror 549?
We do not have any objection to juror 549 being excused for hardship.
All right. Thank you, counsel. The court's considered the responses provided today, as well as the position of both the state and the defense as to a request to be excused for an undue hardship, finding that financially it would create an undue hardship for this particular juror given the length of the trial, the court will grant the request to be excused. So juror 549, you can be excused from your jury service. I'll indicate something to you now, and if any other jurors are excused, I'll give a more abbreviated definition here. But so juror 549, thank you for coming and filling out your questionnaire last week, coming again today. The court appreciates your time and service. If you decide to discuss this case with anyone, please be careful to respect the privacy and feelings of your fellow jurors. Please limit your comments to your own perceptions and feelings. And if anyone persists in discussing this case with you over your objections or becomes critical of your service, please report that to the court, and the court will take that up with whoever has engaged in that behavior. So that will conclude my remarks to you today, and you can be excused. All right, let's next discuss the issue with juror number 615. If you'd raise your card, please. All right.
Basically, I'm the primary provider for a special needs child, my daughter. During the day, she does attend school. During the evenings, though, is when I take care of her. I do have assistance with that, but depending on the length of the trial, or if we were sequestered, then that would cause a little bit hardship with her. She has a primary person that she responds best to and works best with, and that is me. So if we're sequestered, that would make things pretty difficult for her and for myself.
Okay, so during the course of the trial, if it was not during a time sequestered and we were ending around 3:30 each day, how would that comply with the schedule you've got with her?
That would comply. She gets home around that time, and then I'd be able to take care of her in the evenings.
All right, so the question would be whether or not there was a time when the jury was potentially sequestered in the case?
Yes.
Okay, and I will note that's not determined at this point, but it is a possibility, so your concern is well taken. I'll go ahead and pass this for the state if they have any additional questions regarding your request.
Judge, we don't have any questions for this juror.
All right, from the defense?
Your Honor, we don't object to juror 615 being excused for hardship.
All right, the court's considering that as well. Does the state, didn't have any questioning, but do you have any objection to the hardship excuse request?
Judge, we do not have an objection.
All right, juror 615, then the court has considered your responses here today, given that there's a possibility of sequestration, and we wouldn't know that until the case was fully submitted. It would potentially create an unnecessary hardship for you and your family to require you to serve in this particular case. So again, thank you for your service today, and that same admonishment I gave about discussing the case, or if anyone wants to discuss the case with you, applies. So with that, you can be excused, and thank you. Let's next talk to juror 667.
Yes, this is the first time I've ever been in a jury or anything like that. I've never been in a courtroom for it. So you were saying that it could go on for 8 weeks. I'm not sure if it's Monday through Friday each week. Right now I've got 80 hours of jury paid, or jury duty paid hours, and then anything over that I've got 2 weeks paid vacation that I can use. Anything over that, it's unpaid.
All right, so to clarify, the 8 weeks would typically be the full Monday through Friday, each day, 8:30 to 3:30, and that's information you received from your employer after advising them you may be called to serve in this case?
Right. Yes.
Okay. I'll ask the state if they have any follow-up board dire for juror 667.
Judge, the state will not have an objection to this juror being released based on his representations here today. There were some other things the state was going to inquire further on, but I think this would be a reason to have him released as well.
All right, thank you, Ms. Blake. Mr. Archibald for the defense.
We do not object to juror 667 being excused for hardship.
All right, the court's considered the request, and juror 667 will be allowed to be excused based on a hardship through the representations made about what would occur through loss of income if this trial went as long as expected. So juror 667, you're excused, and the same information I gave the other jurors about talking about the case, or if anyone talks to you, would apply. So with that, you can be excused with the thanks of the court for reporting today. Juror number 676.
I was originally unemployed when I filled out the questionnaire. I started on Friday. I am the main earner of the family. My wife does have a small part-time job, but because I've just started, I'd have no eligibility for jury pay or anything like that. It doesn't kick in for 30 days at my new company.
All right, the court, juror 676, reviewed your responses in your questionnaire, and you did indicate that you had been searching for a job, so that would be some updated information that's occurred just since last week. Would you just advise the court and the parties of where you're currently employed?
The name of the company?
Yes.
EE Tech Media.
And when did you begin that employment?
Friday.
All right, any questions for juror 676 from the state?
No, Your Honor, the state would have no objection based on the new information for this juror being released.
All right, any response from the defense?
We do not object to juror 676 being excused for hardship.
Very well, the court's reviewed the information in the questionnaire, which did confirm this particular juror was seeking employment at the time the questionnaire is filled out, having just started new employment. Not surprisingly that wouldn't go over well to have 2 months immediately off for the length of this trial, so the court does find that juror 676 has presented a reason to be excused for hardship. So thank you again for reporting today and filling out your questionnaire last week. You're excused with the same admonition I gave the previous jurors about any communications that you make or others want to make with you. And with that, you can be excused. Let's next talk to juror 682.
Good morning. So I guess I didn't realize there was a part on the questionnaire that talked about finances. I was pretty nervous. I work as a surgical nurse, and this would be not only a hardship on me financially because I have debts to pay, but also on them because we're short-staffed. In fact, they asked me to come as soon as I could today after I'm done here, just because, you know, for patient safety, it's important to have an adequate staff, and it's been a real struggle to meet those needs at our surgical center. And I also have a small, you know, we run a farm, and I have a small side business breeding horses. I have some debt related to that, and 8 weeks of no pay would be a hardship for me to not be in default with those debts. And my work does not give any compensation for jury duty.
Okay, I reviewed the questionnaire you've got as it relates to what you listed in your employment. So just to confirm, you did discuss with your employer the potential you'd be required to serve, and that's what they advised you about their policy for compensation?
I did ask her. Obviously, she knows I'm here because I'm not at work. She said she would get back to me on their policy. She didn't know what it was. But I've been a nurse for 30 years, and I've never worked for anybody that compensates so far. It would be unpaid time off.
All right, let me ask the state if they have any follow-up questions for this juror.
I think, Your Honor, just with the compensation, we didn't know, is it possible that you could ask your employer to determine whether or not you would be compensated for the time that you're serving on jury duty?
It's possible, yes.
I think that's the only question that the state had.
Okay, thank you, Ms. Blake. Mr. Archibald, any questioning from the defense?
Your Honor, we do not object to Juror 682 being excused for hardship based upon her job as a nurse and her part-time job with her horses.
All right, the court's considered the hardship request from Juror 682, and based on that information received, the court will grant the excusal for hardship for this particular juror based on the work situation and your financial obligations at this time. So Juror 682, you can be excused with the thanks of the court as well. Also, with that same admonishment I've given the other jurors about communications after your service today. Juror number 696.
Good morning.
Good morning.
I may not provide income for my family, but I take care of everything else. We do not put our children in daycare for their safety. So if I am here, my husband's at home not making money. Because he's not on the jury, I am.
Okay, you currently have 3 children at home, is that correct?
Yes, sir. I also take 3 additional children from the neighborhood to school as well.
All right, I saw the concerns you did raise in the questionnaire about those issues, and you thought at that time you filled out the questionnaire it may be a hardship if you were required to serve with that child care obligation. Let me ask the state if the state has any follow-up for Dyer for juror number 696.
Your Honor, I think she answered the additional question. The state's question, based on the questionnaire, had been whether or not her spouse was able to care for the children. We'd noted the comment that they do not allow daycare or others to watch their children. I think she has now answered that question, and given the response today, the state would have no objection to her being excused.
All right, thank you, Ms. Blake. Mr. Archibald from the defense.
Your Honor, we do not object to Juror 696 being excused for hardship.
All right, thank you. Juror 696, we did review that issue based on your responses when we went through the questionnaires, and with those follow-up questions, the court's in agreement that it would create a undue hardship for you to serve in this case, given the length of time with your child care obligations, so you can be excused with the thanks of the court. I think we also had your 869, is that correct? 9? Okay. I may have, thanks, I may have made an error in my notes here on the numbers. Was there any other juror that raised an issue about hardship? Okay, thank you. The next topic we would generally discuss would be the knowledge of the case. Many of you have indicated some knowledge of this case in your questionnaires. At this point, instead of asking who that would be, let me just ask, is there anyone in the group here that did not indicate they have a previous knowledge of this case? You didn't know anything about the case until you came in for jury service, and that's the response in your questionnaire. So each of you has heard something or knows something about the case through media, is that correct? Okay, we'll talk to you all individually about that issue when we get to the end of your voir dire. I'll next ask you about the subject matter of this case. Would the subject matter of this case, which includes charges involving murder, conspiracy, and theft, make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? Okay, everyone answered no to that. I'll next go through a line of questions which you might think are or should be obvious from reading your questionnaires, but I'm required to read these to go through some Idaho law that would relate to challenges for cause. Are any of you related by blood or marriage to the defendant, or do you know her from any business or social relationship? Do any of you have any relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger between you and any of the attorneys in this case? Have any of you been a party in any civil litigation against the defendant, Ms. Vallow Daybell? Have any of you ever brought a criminal complaint against Ms. Vallow Daybell or been accused of a crime by any of the prosecutors involved in this case? I'll next ask if there's any relation between you and any of the attorneys or their firms. So in order to do that, I'll ask the state to indicate who you are and who you work for and what other attorneys are in your office. I don't know if you both want to take that up or one speaking for both. Ms. Blake, if you'll go through the office attorneys and introduce yourself again for the jurors.
I am Lindsay Blake with the Fremont County Prosecuting Attorney's Office. With my office, the other attorneys are Tanya Rawlings, Rocky Wixom, and Blake Hall. As you were already introduced, Rob Wood is the Madison County Prosecutor. Within his office are the attorneys Mackenzie Cole, Spencer Rammel, Adam Garvin, Troy Evans, and then as you've both been introduced, we have Ms. Smith here, who's been deputized in both Fremont and Madison County and is working as a deputy prosecutor for both counties.
All right, thank you, Ms. Blake. Mr. Archibald, would you please introduce yourself and the nature of your office?
I'm a sole practitioner.
All right, and Mr. Thomas, who do you work with?
Thank you. My name is John Thomas. The other attorneys that I work with are Jordan Crane, Jason Gustavus, Timothy French, Alex Sosa, Tyler Salveson, Brad Rigby, Paul Butikofer, and Justin Bowles.
All right, thank you, counsel. I'll note that these attorneys, with the exception of Ms. Smith, all generally practice or have practiced in eastern Idaho. So with those names in mind, then I'll ask the jury panel here, do any of you have an attorney-client relationship with any of the attorneys or with any of those other attorneys they work with? Are any of you related by blood or marriage to any of the lawyers, or do any of you have or know any of the lawyers from a professional, business, or social relationship? Yes, juror 631.
We do have an office in Idaho Falls and Pocatello, which is over in that area. I don't work in those offices. I work out of the administration office, but I am affiliated with Idaho Legal Aid. I just want to make sure that's not going to be issues.
Okay, I appreciate you providing that information. In the course of your employment, have you ever dealt personally with any of the attorneys who we just mentioned?
No, I have not.
All right. Have you been exposed at all in any way to this case through the course of your employment?
No, I have not.
Okay. Thank you for that follow-up. I'll next ask the question about prior jury service. Have any of you previously served on a jury? If you have, please, let's see, we have some yeses and nos. So if you have, raise your red card, please. Okay, juror 818 and 536. I'll talk to each of you briefly about that. So juror 536, how many times have you previously been on a jury?
Once.
And where was that?
It was here in Ada County.
How long ago?
15 years.
Okay. You must have been at least 18 then, I take it.
Barely,
okay.
But yeah.
Was it, if you recall, a civil or a criminal case?
I think it was criminal, but I'm not positive.
And did you actually sit through the trial and reach a verdict in the case?
Yes.
Was there anything about your experience of that jury service that would impact your ability to be an impartial juror in this case?
No, it was a really good service. It was a good experience.
Okay, thank you for those comments. I'll next ask the same questions. Juror 818. When was it you previously served?
13 years ago.
And was that one time prior? Once?
Yes.
And where were you in that?
San Diego County.
Okay. Do you recall if it was a criminal or civil case?
Criminal case.
And do you recall if a verdict was reached in the case?
Yes, we reached a verdict.
Okay. Was there anything about your experience serving in that case that would impact your ability to serve in this case?
No.
Okay. Thank you for that comment. I'll next ask a few more general legal questions here for you. Have any of you ever formed or expressed an unqualified opinion that the defendant, Ms. Vallow Daybell, is guilty or not guilty of the offenses charged in this case? Do any of you have any bias or prejudice either for or against the defendant in this case? Okay, the next issue would be regarding witnesses. In the questionnaire, there was a list of witnesses, and you each indicated whether or not you knew any of those witnesses. To the best of your knowledge, are your answers in the questionnaire still accurate as it relates to knowledge of witnesses?
Yes.
Okay. Is there anyone here who would be unwilling to follow my instructions to you as the jury as to the law that you must apply in determining this case? Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict? Are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based only on the evidence presented in this courtroom and the law as instructed by the court? All right, finally, kind of a catch-all question here. Do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, with the jurors answering all of those questions at this point, then the court has concluded its section of voir dire. I'll let the state now conduct its voir dire of these jurors.
Ladies and gentlemen, thanks for being here again today. I know you were all here last week as well, so we appreciate you hanging in there with us for this process. Just to clarify a few things with you, maybe a little confusing to hear that we have two elected prosecutors here from both Fremont and Madison County. If you recall from when the judge read the indictment, though, he talked about that these crimes were alleged to have taken place across both counties. We're both small offices, and so we've joined together in the joint prosecution of this matter. It's not often that you hear of two counties prosecuting together. So in case anyone was confused by that, we just want to clear that up. And then I want to talk to you a little bit and reemphasize the judge has let you know this as well. But because we are trying to make sure that we select a jury that can be fair and impartial, if at any time there is something that you're uncomfortable with, you're asked a question that you don't want to talk about in front of everyone, there's information that you feel like we should have or that you should share with us, please don't hesitate to raise your hand and let us know that you'd rather talk one-on-one or individually. We recognize that that may be a concern for some people, and we'd rather than have you hold back or have concerns, we want to make that as comfortable as possible to make sure that we are selecting a jury that can be fair and impartial, because that is only fair to Ms. Vallow Daybell, the defendant here, as well as the state, to have everyone do that. And so one of the things that I want to ask about is brutal honesty and what that means. Juror 818. If I use the term brutal honesty, what does that mean to you, or what comes to mind?
I would say saying the entire truth and not holding something back for fear of future, ramifications.
Okay. And juror 646.
Being completely honest without holding anything back for fear of hurting the other person's feelings or thinking how it might make them feel.
Okay. So I think we heard very common things there. Would everyone agree that brutal honesty is just telling the truth how you see it, not holding back even if it might hurt someone else's feelings? And does everyone here feel that they could be brutally honest? And when you're discussing with other people, while we want everyone to listen to others, could you all commit to being brutally honest with your feelings and your thoughts? And I'll ask you all and give a little analogy here. If you got on a plane and instead of the pilot telling you, hey, we're going to arrive at the destination at such and such time, I'll get us there safe, sit back, enjoy the flight, if instead the pilot said to you, I might be able to land this plane, we might get there at this time, would anyone feel comfortable staying on that plane? Okay. And I'm going to ask juror 863. I think you answered no. Why would you not feel comfortable staying on that plane?
I would feel unsafe.
Okay. If the pilot, if you had the choice to get on one of two planes, and one, the pilot said, I can land this plane, I know I can, and yet another one that said, well, I think I can land this plane, which one would you choose?
The first one?
The pilot that could land the plane?
Yeah.
Okay. And I'll ask the same question to 869. And why would you not why would you not feel comfortable on that plane?
I wouldn't have confidence that the pilot knew what he was doing.
And if you were given the option of one that could for sure land the plane and one that might be able to, which one would you choose?
The pilot that can land the plane.
Okay. And I know that may seem like a silly question, but the reason that we ask that and the reason that I want you all thinking about that is we are going to ask you all to be the pilot in this case. You are going to be the ones that listen to evidence, you go back and consider it, and you make a decision. And sometimes people will say, I think I can be fair and impartial. I think I can follow the judge's instructions. And so that's what we want you thinking about. We need to know that the jurors can follow the instructions given by the judge. The judge may give some instructions that you may say, I don't agree with that. I think it should be this way. I think the law should say this. Can all of you commit that you would set any of that aside and just follow the instructions given by the judge?
Yes.
Does anyone have concerns about their ability to do that?
No.
Okay. Does anyone here believe that everything you hear in the news or read on the internet is 100% true? And I'm going to ask Juror 401, why do you not believe everything that you see in the news or read on the internet is true?
Well, they're trying to sell it and make people watch it.
So so do you feel that different sources may give different information?
Oh, yes.
And same question for 536. Do you feel that everything is true and accurate?
Not as far as the media goes, no.
And for the same reasons, or do you have other thoughts on why?
I think the same basic reasons. Everyone has a point of view, and often news agencies have agendas, and they want clicks. Like, we all know what clickbait is.
Okay. Thank you. And as the judge already talked about, we're going to talk a little bit more about publicity later. I just wanted to make sure that nobody would say that they absolutely believe everything that they read on the news or read on the internet. As the judge already talked about, and you've heard the indictment, the nature of this case is could be a touchy topic for some people. We are dealing with a case in which 2 children were murdered and a mother of 5. Knowing the nature of this case, that you are going to hear evidence related to those types of charges, does anyone have concerns about their ability to sit on this jury? And along those lines, some of the evidence that you may see in this case may not be the easiest to view, may be upsetting to some people. While it's normal to be upset by some things, does anyone here feel that looking at some evidence, maybe autopsy photos, maybe something else that you find upsetting, would that create a concern to anyone regarding your ability to sit on this jury? And 891, go to you. And can you expand a little bit on that?
Yeah, I was a witness a very horrific accident in my childhood. When I see graphics, it's affect my overall ability to make a proper judgment.
So, and I just want to follow up a little bit on that. So when you say it affects your ability to make a proper judgment, or would you be able to set those images or that evidence aside, or do you feel that it would influence your ability to be fair and impartial?
I could set those, my personal feeling aside to be fair, but it could impact my emotions and my ability to, in the long run, to maintain my emotional balance.
So, and of course, we expect those things to maybe be upsetting for people. Do you feel that that would be more than what would upset a normal or a regular person if you hadn't had those experiences in your childhood?
It's a very difficult to make a statement, but whenever I see some graphics, it's emotionally impact me. I cannot withstand that.
And I think you'd also indicated that you have a young child.
Yeah.
Do you feel that that would be difficult to see photos of children?
If the the further graphics, then definitely I cannot forecast what could be my emotional feeling at that time. But whenever I see a graphics, anything which is not normal, something is there's some kind of the blood in there that sometimes it impacts. And I just to be honest, when any kind of graphics I plays anywhere in news, it impacts my feeling and recall my childhood when I witnessed a very horrible accident to us.
And I appreciate your honesty, and I'm sorry to put you on the spot there, but that's exactly what we want to when we're talking to you today. We talk about brutal honesty with each other when you're allowed to speak about the evidence and go through these things, but we also mean brutal honesty here today. And so given that information and that position, do you, I guess actually the state would just move to strike juror 891 for cause.
Okay, what's the response from the defense on the motion?
We do not object to juror 891 being excused for hardship.
Okay, in this case, the court's reviewed the challenge as well as the questionnaire of juror 891. The issue expounded on in voir dire questioning was also raised as a concern in the questionnaire, and further concerns that were raised in terms of possible hardship given the length of the trial. But with those responses and in anticipation of evidence that may be presented in this trial that may unfairly impact this potential juror or cause issues with their impartiality in the case, the court does find it's appropriate to sustain the challenge. So juror number 891, the court will allow you to be excused in this case, grant the state's challenge, and you can be dismissed. The court will advise you, as I did the other jurors, to please, if you're talking to anyone else, if you talk to anyone, please follow that admonishment to be careful to respect the privacy of the other jurors in this case, and if anybody persists in talking to you, please report that to the court. And with that, thank you very much for coming. All right. All right, Ms. Blake, you can continue your voir dire examination.
Thank you, Your Honor. On the still talking about some of the evidence you may see, can I ask juror 849? I believe you have several children.
I do.
And they're old. They're a little older now.
They're adults.
Would looking at images of children, graphic images, images that may be disturbing for some, do you believe that that would cause you any concern?
Yes, it would cause me concern in that I don't think that's the type of thing I'd like to look at or want to look at. No, it wouldn't cause me concern as emotionally damage me, but that's not the type of thing I'd want to look at.
If you were to look at evidence like that, do you feel that your reaction would be such that it would overcome your ability to weigh other evidence presented and render a fair and impartial verdict?
I do not.
Thank you. And juror 631? I believe you have a child.
I do.
Do you believe seeing images of children that may be upsetting to some would cause you concern?
No, I do not.
And do you feel that if you were to view evidence like that, you'd be able to still weigh other evidence presented, give all the evidence the weight you think it's due, and render a fair and impartial verdict?
Yes, I do think I can.
Thank you. And I'll just reemphasize, and I know the judge touched on this as well, but all parties deserve a fair and impartial trial, both the state, Ms. Vallow Daybell, and we also have victims. So does anyone with this additional information have any concerns about your ability to sit on this jury, review the evidence, give it the weight you think it's due, and render a fair and impartial verdict? I'm going to turn the time now to Ms. Smith with the state for some additional questions.
Morning. We'll just ask some few questions, and I'll start with a couple of specific questions on some of your stuff in your questionnaire, okay? Let's turn to, pull up my little notes. Juror 401. Ma'am, you heard the judge read the instructions about beyond a reasonable doubt, correct?
Yes.
Okay. And in hearing that instruction, I understand that sometimes hearing the instructions and comparing to what you see on TV or what we hear, there can be a difference. Do you agree with me?
Yes.
Okay. You understand that the instructions that the court gives are the only law that you follow in this case, correct?
Yes.
All right. Not something we might have read somewhere else, not some other definition we think about on TV, right?
Right.
Okay. And the court explained to you that the state bears the burden of proof.
Yes.
Okay. What does that mean to you?
The defendant is innocent, and the state has to have all the proof. They bring all the evidence.
Okay. Yes. The state, and only the state, and in this case, the people of the Idaho are represented by the prosecution team over here. And so when the judge says the state bears the burden of proof, that means us. And we're the only ones that have anything to do on this case, right?
Yes.
And you said a phrase, all the evidence. And so you understand that the rules and the instructions the court gives you guide what is allowed in a courtroom.
Yes.
All right. And we'll touch on this more when we do individual conversations about the media, but sometimes there'll be things that are floating out there that jurors might want to see, or they've heard rumors about, or a type of evidence that they might want. And it turns out it's not actually allowed in a courtroom. Does that make sense? Okay. And so some people are like, they'll say the phrase, I hear everything. I want to hear everything, or I want to see all the evidence. And then only certain things come before them, and it causes them frustration. Like they have an idea that there's something floating out there, but they don't get to see it. And then that can block their ability to follow the rules of the court. Do you think if you'd heard about something, or there was a type of evidence you wanted to see, but it wasn't brought before you, that could cause a challenge for you in considering whether or not to convict someone?
No. Okay. I can only know what's in play here.
Right. Exactly. Now, Juror 630, thank you, ma'am. Juror 631. I'm sure you heard my conversation with Juror 401, right?
Yes.
Okay. I noticed some of your answers talked about, on your questionnaire, talked about all doubt or no doubt. Did you hear my conversation with Juror 401?
Yes.
Okay. You understand that sometimes there are things that either aren't true out there and that they don't belong in a courtroom, or that for other reasons they just aren't relevant. They don't come in here.
Correct.
Okay. And is anything about the idea that the decision must be based only on the evidence in this courtroom going to cause a challenge for you?
No. If it's not brought in the courtroom, it may not be true. It may be made up, quote, evidence. Basically, if it's not in the courtroom, the court has decided it is not relevant to this case, and it may not be true.
Okay. And so following up on that, you understand that it's the state's job to prove every part of the charge beyond a reasonable doubt?
Correct.
Okay. And that the instructions you get, there'll be pieces of paper you take back with them, have definitions on them?
Correct.
Have you ever seen jury instructions before?
I have not.
Okay. Do you have any role in filling out jury instructions?
I would assume that I would have to read and follow the jury instructions.
Right. I'm sorry. That was probably I clearly might need more coffee this morning. The jury instructions with your employer, do you have any role at legal aid in helping any of the attorneys do jury instructions?
No, I do not.
Okay. You ever seen any of the jury instructions?
I have not.
Okay. So understanding that, I thought maybe you might have some places use people in lots of different ways, so I wanted to ask about that. Okay. The instructions the court give you will define what each of these things mean, right? Conspiracy, murder, grand theft.
Correct.
Each of those things will be kind of like a recipe. They'll have parts to them. And each of those parts the state must prove beyond a reasonable doubt. Does that make sense?
Yes.
All right. If those definitions that the court gives you and are different than what you think the law is, or like what you think you've heard about, are you going to have any trouble putting aside sort of your personal ideas, your personal beliefs sometimes, and following the instructions that Judge Boyce gives you only?
No.
Okay. Is there anyone here? Thank you, ma'am. I will come back to you in a minute, but is there anyone here who heard my conversation with Juror 631 or 401 is like, no, Ms. Smith, you know what? I heard what you said, but if the definition given to me by the court doesn't match my own personal beliefs, doesn't match what I think the law should be or I want it to be, I got to go with my own gut. And that's okay. That just means this isn't maybe the case for you. Does anybody feel that way? Okay. You understand that in order for us to be fair to both sides, and it's too important to Ms. Vallow Daybell and to the people of the state of Idaho and JJ, Tylee, and Tammy, that the jurors in this case don't superimpose their own standards, ever. Does that make sense to everyone? Okay, it really is fundamentally about being fair to both parties in this case. So that means if you have a different definition, that means that maybe this isn't the case for you. Does that make sense? Okay. And coming back to Juror 631, I do want to ask you, a couple of times you said in your questionnaire, and I want to make sure that I'm understanding it, that we can't pass judgment unless there's no doubt.
Correct.
Okay. Now, the court's instruction that he gave you talked about a doubt based on, a belief based on reason and common sense. Did you hear that when the judge read it to you?
Yes.
Okay. And that is different than no doubt.
So in my understanding of what the judge has said of beyond a reasonable doubt, that means the state must prove to me that beyond, that there's no question that this, whatever accusation has actually happened before I can pass judgment. So it must be proved without a doubt, or a reasonable doubt, that it happened.
Okay. And so that, and a lot of people will say things like that. That's why I spend some time chatting about that. And so let's do it this way. Under the law, somebody who is a witness to a crime can't be a juror. That makes sense, right? Because they'll have observed it. They will have no doubt because they saw what they saw and they knew what happened. And so jurors are told they have to render a decision, and the court read you that instruction, that is a finding of guilt beyond a reasonable doubt that is based on reason and common sense. Does that make sense?
Yes.
So the only way to remove all doubt is if you're a witness, right?
True.
Okay. So jurors are left with, did the state prove each of the parts of the crime beyond a reasonable doubt? But we can't possibly remove a doubt on any question. Does that make sense?
Yes.
Okay. Given your concerns or your statement in the voir dire, do you think you can follow the court's instruction?
Yes, I do.
Okay. And do you think you're going to be tempted to want to remove all questions or all doubts?
No, after your help explaining that, it does make more sense to me.
Okay.
That there may be slight questions still in play, but we have to make that decision based off of the evidence and the case presented, beyond the reasonable questions.
Right. Only witnesses can remove all doubt, right? The question is, did the state do their job and prove each parts of the crime beyond a reasonable doubt to each juror and to the jurors on the panel as a whole? Does that make sense?
Yes.
Okay. Thank you, ma'am.
Yes.
Juror 818. You heard my questioning of Juror 631, right?
Yes.
Okay. Is there anything about that conversation we had that causes you concern about your ability to follow the court's instructions?
No.
Okay. You understand that it's the state's job and only the state's job to prove beyond a reasonable doubt what's going on?
Yes.
Okay. And you had prior jury service, right?
Yes.
Okay. And forgive me, I didn't put on my cheat sheet whether that was on a criminal case or a civil. I should have.
It was a criminal case.
Okay. You understand, is there anything about that experience or those definitions in particular that's could interfere here?
No.
Okay. The judge doesn't just make up the instructions. He gets them based on his research of the law, some instructions given to him by the Supreme Court, rulings of the legislature, but instructions are unique to each case. So the court tailor fits them to the charges and to the person before them. Do you understand that?
Yes.
Is there any chance on that case you're going to be thinking about in that other case, the judge did this or the prosecutors did this?
No.
Okay, you can assure both sides that there's nothing going to be creeping in your mind and doing a compare and contrast.
Yes, I can confirm that.
Okay, thank you. Okay. Now, we've gone over the concept of and talked about presumption of innocence. We've talked about beyond a reasonable doubt. We now need to talk about the court, and I want to talk to juror 849. Okay. And I heard your questions with Ms. Blake, so I'm not going to repeat them. But understanding that there's going to be some evidence that I candidly probably nobody on the jury wants to see, but if it's admissible, they will see. Do you understand that?
Yes.
Okay. So let's talk about evidence. The court's going to give you instructions on what the law is and what we must prove beyond a reasonable doubt. And he's not going to tell the state how we have to do it as long as we follow the rules. So he's not going to say you must bring in a certain type of evidence, that you must bring in certain types of pictures. He's going to take what we offer. If we do it the right way and it's admissible, he's going to allow the jury to consider that to prove those elements. Does that make sense?
Yes.
Okay. So he's going to tell the state, follow the rules, but I'm not going to tell you how to try your case. Does that make sense?
Yes.
Okay. And so there may be times that on a case where the prosecutors will submit evidence called circumstantial evidence. Have you heard about that before?
Yes.
Okay.
I don't know that I'm an expert, but yes.
Well, and I'm not going to, I want to try to, that's why we do this conversation. What if people heard? And I often use the analogy in a lot of places, people will hear of the crime of breaking and entering, right? And then they get surprised when in their area, the charge isn't called breaking and entering. It's actually a term burglary, that sort of thing. And then the definition of what they think is out there is different. So that's why we're having this conversation about circumstantial evidence. And given some of your answers on the pictures, I wanted to chat with you about that. And so let's use, I think it might make it easier. If you were at an event and there was a cookie jar in the kitchen, and some of the kids at the event were told by all the adults, stay away from that cookie jar. Do not eat the cookies. They are for later on. And you come in to the event and you walk in and the cookie jar's open and one of the kids, as cute as they are, is standing there, got cookies on their crumbs on their face, chocolate in their mouth and on their teeth, chocolate on their hands, and the cookies are gone. Are you firmly convinced, do you believe reasonably that that child has eaten the cookie?
I think I would, yes.
Okay. Now, remember Ms. Blake's analogy of the airline pilot? Is it I think, or would you? That's why she does that example, is so that, because it's just too important to both sides to not deal in that gray of I think.
I would assume.
Okay.
Yes.
Okay.
The child ate the cookie.
Okay.
Or cookies.
Right. That's circumstantial evidence.
Right.
That led you to a belief And would you expect them to be held accountable based on those circumstantial evidence?
Yes.
Okay.
The hesitation is if the child came later and didn't hear the instructions, I'd want to know. But yes.
Absolutely. Absolutely fair. And that's a fair clarification. And the next time I talk to a jury, I'll make sure I include that. The children all heard they weren't supposed to do it, right? Fair enough. And so knowing they heard that, we would expect to hold that child accountable, right?
Yes.
Okay. Even though there isn't maybe an eyewitness.
Right.
But the circumstances lead you to the belief, reasonable and common sense lead you to believe that they did it and they need to be held accountable, right? Yes. Now, taking that fact pattern, if somebody is charged with actual crime and something more serious, could you consider convicting somebody if enough circumstantial evidence was given to you to prove all of those parts beyond a reasonable doubt? Could you consider convicting somebody of a crime, say murder or conspiracy, based on circumstantial evidence?
Yes.
Okay. Is there anyone here who's like, Ms. Smith, I hear what you say, and even if I believe each of those parts beyond a reasonable doubt, and under the law, if you believe all of those parts beyond a reasonable doubt, your verdict must be guilty. But if that's all I've got is circumstantial evidence, I couldn't consider convicting someone of a crime based on circumstantial evidence alone. No. Juror 401, any concerns with that? I can see you thinking.
Oh, I was just thinking if that's what the rules were. If that's what the rules that to convict on circumstantial, then I would have no problem with that if that was the rules.
Okay. And if that is the rules, and that you receive information that allows you to consider that, you could do it.
Right.
Okay. What about you, Juror 863?
Sorry, can you say the question again?
Sure. You heard my conversation with Juror 849?
Yes.
Okay. And my conversation with Juror 401?
Yes.
Okay. Could you consider holding somebody accountable under the law of serious crimes based on circumstantial evidence if you believed beyond a reasonable doubt each part of the crime?
Yes.
Okay. Is there anyone here who has hesitation on that? Okay. All right. Now, in this case, I anticipate you're going to hear from lots of different witnesses, and let me turn to Juror 646. If Juror 646, I was looking at some things, and if a witness had religious belief or ideas, strongly held ideas that were different than your own, and then they testified, is there anything about them having different beliefs than you do that would cause you hesitation in believing their testimony?
No hesitation in believing their testimony.
Okay. And so you'd be able to assess the credibility of someone whose testimony is different, someone's testimony, even though they may have a different belief system than you do.
No issue with their testimony, but the interpretation of the law is no different.
Okay, fair enough. Is there anyone here who's like, look, if I didn't understand why somebody believes something, or it didn't make sense to me how someone could believe that, I don't think I could consider that person's testimony? Okay. All of us agree that people need to be judged on how they present in the courtroom, right? And that we can consider lots of factors in assessing their credibility, but we don't automatically disbelieve them because of their personal beliefs or their religious beliefs, correct? Okay. And so when we're talking about witness credibility, is there anyone here who needs to hear from a certain type of person or has ideas in their head of the type of evidence they need to see brought before them or the type of testimony they need to see? Okay, any expectations? Okay. need to run through some specific questions. I'm almost done, Judge.
Okay.
Juror 401, I understand you're an author.
Yes.
Okay. And I understand you belong to an authors group and are in leadership in that group?
I'm on the board.
On the board. That's leadership, and board work takes a lot of work. So if you hear evidence that one of the co-defendants or one of the co-conspirators is also an author, is that going to cause you any concerns or are you familiar with any of the works of Chad Daybell?
No, it doesn't ring a bell.
Okay.
I'm sorry.
Is there any? No. And that was a compound bad lawyer question. That was two parts. Let me break it up. You're not familiar with any of Chad Daybell's?
I'm not.
Okay. Is there anything about the fact that he has a publishing company or has some books to his name on the title?
No.
Okay. Any tendency to kind of identify or feel sympathetic?
No.
Okay. Thank you. I also chair 401. And again, reiterating our job, because it's too important to both sides, sometimes we have to ask questions if that may seem personal or, and if you, at any point, it's not us trying to be nosy, it's us trying to really do the best job by both sides. So I understand you have some family members who are victims of crime?
Yes.
Okay. They were minors, correct?
They were.
Okay. Is there anything about that situation that's going to cause you to sort of identify or compare contrast to crimes against children? Two of the victims in this case were minors. Is there anything about your personal situation with family that's going to make it hard for you to sit about evidence? Now, there's no allegations of the form of abuse that your family members suffered, but is there anything about those two situations that's going to cause you to have a difficult time giving both sides, sort of that clean slate?
No, it won't. I don't want to, see and hear and know what I'm afraid is coming up, but that's in general, not because of my family members.
Okay. And let's talk about that. It is not unusual when you're dealing with a situation where there are crimes involving children that people of normal persuasion don't want to hear this, right? But if we take that step back and using our reason and our common sense, if everybody who cares about children, who likes children, has children, is removed from a jury, are we going to have a jury that reflects our community, right? We're not, are we? So the question is, it is normal to react to harm to a child. That's normal. The question is, and Ms. Blake touched on this, but since you brought it up, I'm going over it just a little bit. Is your feelings on that issue such that your reaction in this case will cause your emotions to be in the driver's seat, where your emotions affect your ability to evaluate all of the evidence and make a decision based on reason and common sense?
No, I don't think it will affect how I judge the case, even though I'm upset at what's happened.
Right. And that's why we're asking, because there's some people who either personal experiences and one of the other jurors shared that, you know what, this isn't the case for them. And that's where that candor, that brutal honesty is needed. So thank you very much. We appreciate it. Okay. Is there anyone who heard my conversation with Juror 401 who's like thinking about that, or thinking about Ms. Blake's question? I've rethought. I just don't think I can sit and listen to this type of evidence involving what are going to be crimes against children. Okay. Juror 818. Ma'am, do I read that right, that you were on a previous jury in another state?
Yes.
Okay. And that case involved sort of a crime ring, correct?
Yes.
All right. And I read the phrase friend of the mastermind, but no forensic involvement.
Yes.
All right. Without getting into too many details, was it a case in which people were charged as sort of part of a conspiracy or part of a plan?
Yes.
Okay. And in that case, there were some decisions made that the state hadn't met its burden of proof, correct?
Yes.
Okay. You understand this is a conspiracy case in large part?
Yes.
All right. Is there anything about that experience that's going to cause you to do a comparison and a contrast?
No.
Okay. Laws in California are very different than laws in Idaho.
Yes.
All right. And you understand that the instructions given to you by Judge Boyce are going to be very different than what you got before.
Yes.
All right. But given your comment on your questionnaire, you understand that a person can be guilty under a conspiracy for the conduct of everybody who's part of that conspiracy.
Yes.
So the driver of the getaway car is guilty of the bank robbery, even if they never touched a gun and they never went in the bank.
Correct.
Okay. And the person who plans or finances or moves the plan along is as guilty as the person who does the actual deed.
Yes.
Okay. Is there anything about your previous experience or anything you've heard here today that you would have trouble following an instruction like that?
No.
Okay. Thank you, ma'am. Now, the other jurors, you heard my conversation with juror 818, right? Is there anybody here who's like, Ms. Smith, I heard that. I don't think I could hold sort of the driver of the getaway car as guilty as the guy who went in with a gun. Understand, if the instructions tell you that and the law is given to you that says that, the person who participates in the plan and contributes to it is as guilty as the person who does the deed, right? Okay. If I can, I'm going to go back to juror 818. Apparently you're good at jury duty because you get called a lot. So, but that means we get to ask you lots of questions. So on that situation, if a person is, if you hear evidence that from state's experts that will tell you sort of, we know this person died at the hands of another. In the state of Idaho, that's a homicide, died at the hands of someone else. But we can't exactly tell you how that person died. We know it's a homicide, but we can't tell what actually made their heart stop beating or their brain start functioning. Okay? Is there anything about that fact pattern, were the evidence submitted to you, that would make it difficult for you to consider convicting somebody even if you believed all parts of the elements the court gave you?
If the court gave me all of the elements and beyond a reasonable doubt, I would convict them.
Even if you could, the experts couldn't say exactly how the person died, just what manner of death it was?
Correct.
Okay. All right. Thank you, ma'am. Now, I know the other jurors heard my conversation with juror 818. Is there anything about that situation? Ms. Smith, I love my forensic shows, and if you can't tell me exactly how a person died and you only show me that someone killed them, I can't consider convicting someone of murder. Anybody here who feels that way? Juror 849, I didn't see an answer, and it could be just because I was long-winded.
Again, I tend to think thoroughly before I answer, and the answer is no, but I tend to process.
Fair. But that means I just want to make sure we've heard from you and given you the time to think about it.
Yes,
because these are.
It's fair.
Okay.
I don't mind you asking.
Great. So when you say no, does that mean you could consider convicting somebody of a crime of murder, even if the state couldn't show you exactly how the victim died?
That's correct.
Okay. Thank you very much. Let me check with my colleagues, and I think I'm done, Judge. Thank you. Thank you very much.
Okay, we'll pass now for the defense to conduct voir dire of this jury panel. Mr. Archibald.
By the time it's my turn, a lot of the questions have already been answered, so I'm usually pretty brief. I just wanted to follow up on some of your questionnaires about hardship. I still have notes. A couple of you checked the box on hardship on your questionnaire, but you didn't respond that way to the judge, so I just wanted to follow up on that. Juror number 646. You'd indicated on your questionnaire that you needed to work. And is that still the case?
Yes. Then lower in the questionnaire, it noted the hours. With the hours, the company I work for, I can work from home, so I can adjust my work time. I work with a lot of folks overseas, so I have late meetings anyway, so I should be able to work around the schedule.
Okay. So you're not concerned today about your ability to still be able to work if you're called as a juror?
Correct.
Okay. Thank you. Just appreciate clearing that up. And juror 849. I believe you also indicated that you needed to work on your questionnaire, and so I wanted to clear that up with you today.
That is correct. Not knowing what my work's full policy was, I wanted time to check that out. I found out that I would be able to receive compensation while I'm there. In straightforwardness, I have a role that affects a lot of people, and there's good people there that I'm sure would be able to cover, but I am effective at what I do, and it would have an impact, as I'm sure anyone being taken out of work. I also, I'm in computers. I work in computer science, and so I live online, and so if I was to be sequestered to not use the internet, I could not work. And I do interact with people across all time zones in the type of work I do. And so if I'm allowed, I will work. And I also know me, I'm fairly driven and I like getting results. And in order to be completely focused and ability to do what I think would be needed as a juror, there's a temptation I have where I'm results oriented at work and I'd want to work. And so I have a concern that I would have to monitor myself to not overly work two jobs, in a sense, the jury duty and my regular job.
And so are you asking to be excused for hardship, or in your mind, are you thinking, I can work this out?
In my mind, I know I could work this out. I'll be honest, I'd rather not. But I know I could. I'd just rather not.
And it's totally your call. That's part of the honesty that the prosecutors have encouraged us. So it doesn't
If
hurt.
someone took the choice, can I serve and feel I would do it honorably? Yes. Do I understand what's being asked of me? Yes. Do I know that the amount of people that would have questions of me, likely I would be needed unless sequestered? Yes.
So, Your Honor, I'm going. None of your answers are wrong. That's your life. So I'm going to challenge Juror 849 for hardship so that he can work.
What's the response from the state?
Your Honor, based on the juror's responses, I think he's indicated that he could make arrangements and that he could serve on the jury. While someone may rather not, that's not the real question with regard to hardship. I know that's how it was presented by defense, but that's not the real question. So given his responses, the state appreciates his willingness to be here and appreciates his answers in regards to his ability to serve, and we would object to him being removed for cause.
All right. The court's going to overrule the challenge as to this juror based on the responses that he could make arrangements, that it wouldn't at this point necessarily constitute undue hardship.
By saying what that.
So I should be clear. I did not excuse you from jury duty based on your answers. You're welcome.
So it means that I tried, but they said no. So, all right.
I agree.
Okay. Anyone else who is in a predicament at work or at home that you think you... So, Juror 869.
My fellow juror raised a question. Is it a possibility if we are placed on the juror that we will be told to stay off computers altogether? Because I also work, but and I work from home, and I have a very flexible schedule, but my job does require me to be online.
So
I'll answer that if I could.
Yes.
There will be an instruction that you have to avoid being exposed to any sort of media coverage or information about this case while you're serving as a juror. I don't know that the instruction would completely prohibit anyone from accessing computers. It's kind of impossible in this day and age to require that if even you have a phone. I mean, the phones all run off the internet. So I understand the practicalities of that. The instruction is based on ensuring that you're not exposed to any information during the course of the trial that would affect your knowledge of the case.
Understood. Thank you.
You're welcome.
And so are you able to access your computer without seeing the headlines of the day? Okay. And that was Juror 869. Thank you. The other... You've heard a lot of statements about beyond a reasonable doubt, presumption of innocence, burden of proof. Do all of you understand that the defendant does not have to prove anything during this trial? Will any of you hold it against me if I don't prove one thing? Because it's not my job, right? You understand that it's the state's job to prove every element beyond a reasonable doubt. So if the defendant elects, and there's some questions in your questionnaire about this, if the defendant elects not to testify, you can't hold that against me or my client, right? Will any of you hold it against a defendant if they don't testify? A lot of you answered to the question about exposure to media. And this is where I'd like to talk to each of you individually. The judge will have questions, so will the prosecutor, so will I, about your exposure to pretrial publicity. We don't do this as a group because you may not have heard what you heard. So we don't want to poison the well, so to speak. So we're going to take you up each one at a time for those of you who have seen articles or watched the news about the case or read a book or saw some special on TV. So by a show of hands, how many have of you have heard about this case before being summoned to court? All of you. Okay. Your Honor, I'd ask for individual voir dire this panel on the issue of pretrial publicity.
All right. Thank you, Mr. Archibald. We will do the individual voir dire. Counsel, let's take a quick break for the parties and the court reporter here. We'll then start with individual voir dire in ascending order, starting at the bottom of the list numbers. So juror number 401 will talk to you first. We'll then talk to each of you individually, and then that'll conclude the voir dire of this panel. So let's take a 10-minute recess right now.
All right.
Thank you. Please be seated. All right, we're...
We good to start, Your Honor?
Yeah, let's go ahead and go back on the record.
The simulcast is back on, Judge.
Okay, thank you. We're back on the record on KCR 22-21-1624. We took a morning recess and we'll continue with individual voir dire of the jurors from this panel. In a moment, we'll have one brought in. A couple of points I wanted to make on the record before we got started, noting all counsel are present and the defendant here. In this section of the voir dire questioning, counsel, there is a simulcast of this portion of the proceedings, so if we're discussing concerns through media, that will continue to be simulcast. If we go into other topics that involve sensitive matters for the jurors that should not be broadcast to the public, we can accommodate that, but we need to be notified when that line of questioning is brought up, and then we'll be muting the audio that would be simulcast for that portion of the questioning. I'll also just state a concern that's been brought up in terms of making a record in the case. When all jurors in a pool are answering simultaneously yes or no, I think if it's clear that they've all answered, the record's probably satisfied that no one answered alternatively. But when some say yes and some say no and they all speak as a group, that's difficult for the court reporter to indicate what happened. So we probably just need to clarify on the record, okay, everybody said yes except for jurors XYZ answered no. We'll talk to them now, and then we don't have some gap about how a response from some particular juror could have been made there. So with that in mind, then, if the parties are ready to proceed, we'll have juror 401 brought in for individual voir dire. right, welcome back, Juror 401. You're brought in for some additional voir dire questioning in this matter. In your questionnaire, you've indicated that you had some previous knowledge of this case through exposure to news or media in the case, and we just wanted to ask you some questions outside the presence of other jurors on that topic. So I'll ask you a few preliminary questions. When do you think you last heard about this case, either in the news or through the internet or your phone or somehow?
It's been a while. It was when the bodies were found.
Okay, did you ever watch any documentaries, specials, news broadcasts like Dateline or 2020 or Netflix or anything like that?
No.
Okay. Before you were advised of what the defendant was charged with specifically here by the court when you were brought in, before that time, were you aware that she had been charged with any crimes anywhere?
Just these ones.
Okay, and what specifically had you heard about what she had been charged with?
I thought it was the murder of the 2 children.
Okay, that concludes my line of questioning. Does the state have any questions for Juror 401?
Just a few, Your Honor. I did, with regard to the media stuff, I think on your questionnaire you had indicated that you'd seen or heard some stuff regarding the children's bodies being found while the defendant was in Hawaii, and that the bodies maybe were found on a relative's property. Was that all from the same source, or did you learn about that at the same time? Do you recall?
Yeah, I think that was all at the same time. Just, I just remember hearing she'd been extradited from Hawaii, and I don't really remember about the property. I just have a vague idea that they were found on a property, so I don't know where I heard that.
And you don't know where you heard it. Do you recall if it was reading a newspaper article, something on the internet, someone telling you, a news report?
Oh, it would have been something on the internet, something I'd heard. It might have been news. I don't think I ever watched anything on YouTube about it. I think it was just news.
And then I think shifting gears just a little bit, because the judge had asked about hardship before, and I did just want to follow up on the part about if this trial ended up requiring sequestration. You had indicated that if it was for weeks, it would be especially hard for your children and husband. Are you the primary caregiver for your children?
No, we share it. One of us normally takes him to school, another picks him up. It depends on the weekly schedule. So he would have to do it all if I was sequestered.
And so if you were to be sequestered, is that manageable, or would that create a hardship?
I think it would be very difficult for my husband. I think I could also ask my mom to come visit and help.
The state doesn't have any additional questions, Your Honor. Thank you.
All right, thank you, Ms. Blake. Mr. Archibald or Mr. Thomas?
The source of the news then that you remember about this case was from the internet?
Yeah, I don't watch news on the TV. It's always on the internet.
And so the internet feed would be from where?
I think it would probably have been like a local news station just playing while I was on YouTube.
So you subscribe to YouTube?
I'm on YouTube a lot, yes.
Okay. And so that's where an article would just show up?
It would be like a video just saying, like, the news of the day, bodies were found.
And was that KTVB news feed?
I don't know.
Was it like Yahoo News or?
Oh, I would think it would be like a Boise one.
Okay. And what were your feelings when you consumed that news?
Oh, that's horrible that happened.
And what were your feelings when you were summoned for jury duty and determining that you may be called as a juror in that case?
Oh, well, I thought a bad word. Oh, great. That's not great. This is a big case.
Yeah.
It's daunting.
Yeah. And when you look at your phone, do you have like the comment section to your news feed?
Yes, there is one.
And do you read those comments?
Yes. I don't know that I've ever looked at it specifically for this case.
And the comments that you did read probably are not nice. Is that fair to say?
Yes, that is. Yes.
That's fair to say?
Yes, that's fair.
Okay. And so a lot of people share the feelings that you got that, oh, this is a terrible case. Is that right?
Yeah, I would say so.
So having a juror in your state of mind, you're the only one who knows. And do you believe that you could set all that aside and start with Lori with a clean slate?
I think everything I've heard up to this point is rumor. I would think that what is shown here would be the fact and the truth, and I can separate rumor and fact and truth. That's what I would do for this case.
And you're an author, right?
Yes.
And so you write fiction.
Yes.
And so you're able to separate what's true and what's not true through your writing.
Yes.
And do sometimes the lines between fiction and nonfiction get blurred?
For me?
For you.
No.
Okay. And so how about for some of your readers?
Oh, yeah, I think some readers, yes.
Yeah. And so what I'm trying to do here is make sure that we start out with jurors who don't have any preconceived opinions about this case. Do you believe that applies to you?
Yes, I think I don't really know what's going on here, and anything I've heard before, like, I can just disregard. Like, that was just stories, and now I will hear the real truth.
Yeah. All right. Well, thank you. Your Honor, I appreciate your 401 being honest with us about her exposure to the news. I still believe that it may have impacted her. So not to offend this juror, but I do lodge a challenge for bias.
All right. There's been a challenge for the juror. What's the state's response?
Your Honor, I think based on some inconsistent answers with further questioning by defense counsel, the state would have no objection to the defense's motion.
All right. I didn't see anything I thought that concerning in terms of the challenges for this potential juror, but there's a challenge by the defense and now a non-objection to that from the state. There is some detail, not a lot, but detail about certain facts of the case that may or may not come into evidence, which is concerning, which is a result of exposure to pretrial publicity or media or reporting of this case. So for those reasons, the court finds that based on a potential for implied bias here, the juror number 401 will be excused and the challenge for cause is granted.